My name is Vivian Calloway. I'm 63 years old. I spent 32 years as a trust officer at Green Ridge Trust and Wealth Management, reading other people's wills for a living. So when my stepson stood in my own foyer and told me I'd get nothing from his father's estate, I didn't argue with him. I just asked him one question. "Derek," I said, "have you actually read the trust documents, or did somebody read them to you?" He didn't answer that question. He didn't need to. I could see it on his face, the particular blankness of a man repeating a script somebody smarter than him had written. 3 weeks earlier, my husband Harold Calloway had died in a hospital bed in Asheville, North Carolina, 61 days after a stroke that never should have taken him from a man who still had 10 good years left in him. 4 days after the funeral, a codicil surfaced. A codicil none of us had ever heard of, signed 6 weeks before Hal died, in the last stretch of his life when he could barely hold a pen steady enough to sign a get-well card. That codicil named Derek as sole trustee and primary beneficiary of a $16 million estate. It named me for nothing. Not the house. Not the properties. Not $1 of the business Hal and I built side by side for 28 years. I'm a trust officer. I have read 4,000 estate documents in my career. I know what a properly executed codicil looks like, and I know what one looks like when somebody built it in a hurry and hoped nobody in the family would know how to read it. My husband forgot one thing when he let his son and a bought attorney draft that document. He forgot that his wife spent 3 decades catching exactly this kind of mistake for a living. Welcome back to GM Mom Stories, where mothers carry the weight nobody else will carry, and the quiet skill they spent a lifetime building is the thing that saves them in the end. If this story feels close to something in your own life, stay until the end, and don't forget to subscribe. Vivian Calloway, Trust Officer, 32 years at Green Ridge Trust and Wealth Management in Asheville. I started as a teller at 22, the year after I finished my associate's degree in business at Asheville Buncombe Technical College, because a 4-year school wasn't in the budget for a girl whose father drove a delivery route and whose mother cleaned houses on the west side of town. I worked my way into the trust department at 26. By 30, I was managing accounts for families with more money than my whole childhood block had seen in a generation. By 40, I was a senior trust officer, the one they called in when an estate got complicated, when a family started fighting over what a dead man meant by the words he left behind. Here's what 32 years behind a trust officer's desk teaches you. Money doesn't just sit there. It moves. And when it moves without a paper trail, that absence of paper is itself a kind of evidence. I have seen sons contest their mother's wills. I have seen second wives try to write first families out of everything. I have seen documents backdated, signatures traced, notary stamps used without the notary in the room. I have seen almost every version of a family tearing itself apart over money that a dead person can no longer explain. I never thought I would live inside one of those files instead of managing it from behind a desk. I met Hal Calloway when I was 34. He walked into Green Ridge to open a trust account for a strip of commercial property he'd just bought on Tunnel Road, 3 storefronts, and a parking lot he was certain would triple in value inside a decade. He was right. Hal had an eye for real estate the way some people have an ear for music. He could look at an empty lot and see the exact shape of the building that belonged on it. He started with almost nothing, a small inheritance from his own father and a construction loan he barely qualified for, and by the time I met him he had built Calloway Properties Group into 4 office parks, 2 self-storage complexes, and a boutique hotel downtown that he was especially proud of because the bank had told him twice it would fail. Let me tell you about one case from my career, because it explains exactly what kind of trust officer I had become long before any of this touched my own family. 14 years ago, I managed the estate of a man named Walter Pruitt, a retired textile mill owner whose daughter tried to have him declared incompetent 6 weeks after his wife died, using a psychiatric evaluation her own attorney had arranged and paid for without the family's other 3 children knowing it existed. I caught it because the evaluation was dated a Sunday, and the psychiatrist listed on the letterhead didn't see patients on Sundays according to her own office's public schedule. One phone call unraveled the entire scheme. Walter Pruitt lived another 9 years, mentally sharp the whole time, and he sent Green Ridge a fruit basket every Christmas until he passed, addressed specifically to me. I kept that story in my back pocket for decades, a reminder that the frauds people run against the elderly and the vulnerable are rarely as clever as the people running them believe. They are usually just fast, and they usually depend on nobody bothering to check the small details. I never imagined I would need my own advice inside my own kitchen. Hal was a widower. His first wife, Patricia, had died of an aneurysm when their son Derek was 7 years old, collapsing in the kitchen of their home on a Tuesday afternoon while Derek was at school. Hal never talked about that day easily, not even with me, not even after 28 years of marriage. He raised Derek alone for 5 years before I came into their lives, working through grief the only way he knew, which was building things. By the time Hal and I married, Derek was 12, quiet, watchful, careful with his affection in a way that broke my heart a little every single day, because I understood exactly what that watchfulness was protecting. He'd already lost one mother. He wasn't going to hand his heart to a second one without proof she'd stay. I want to be honest about something, because this story only makes sense if I am. I was not Derek's mother, and I never once tried to be. I was careful never to replace Patricia in any of the ways that mattered. Her photograph stayed on the mantle, her name stayed in our conversations, her birthday stayed marked on our kitchen calendar every single year Derek lived under our roof. I drove him to soccer practice and helped him with algebra homework and sat in the bleachers at every game Hal's work schedule made him miss. I was there for the small, unglamorous, daily labor of raising a child, 12 years of it, until Derek left for college at 18. I never asked him to call me Mom. He never did. He called me Vivian, and for a long time I told myself that was fine, that was fair, that a boy who'd buried his mother at 7 owed nobody a second claim on that word. What I didn't understand, not fully, not until much later, was that Derek had spent all those years quietly measuring me. Waiting to see if I was there for Hal's money or for the family. Waiting, I think now, for permission to resent me, because resenting me was easier than grieving his mother, and grief needs somewhere to go. I gave him 28 years of proof that I wasn't there for the money. It turned out that wasn't the proof that mattered to him in the end. Derek Calloway, 38 years old, a mortgage broker at a mid-sized firm in Charlotte, 90 minutes from Asheville. He was good at his job in the years when rates were low and money moved easily. He was less good at it in the years since, when the market tightened and his book of business shrank along with his commissions. He'd bought a house in a neighborhood slightly above what a mortgage broker's income could comfortably carry, the kind of decision people make when they've spent their whole life watching their father build wealth and feel entitled to a shortcut to the same view. 2 boats, one he barely used. A membership at a country club he joined mostly to be seen at it. By the time Hal had his stroke, Derek was carrying almost $200,000 in debt across 2 credit lines and a home equity loan, a fact he had never once mentioned to his father or to me. Ashley Calloway, 34, Derek's wife of 6 years. Ashley worked as a luxury property stager, the kind of business that dresses empty houses in rented furniture and fresh flowers to help them sell for more than they're worth. It is, in its own way, an honest trade, creating the appearance of value where the underlying value hasn't changed. I think about that a great deal now, given what came next. Ashley grew up in Winston-Salem, the daughter of a furniture salesman who never made the money he talked about making. She met Derek at a real estate conference, and by every account from people who knew her before, she fell for him fast and specifically, the way a person falls for a house they've already decided to stage before they've seen the inspection report. I want to be fair to Ashley the way I try to be fair to everyone in this story, because understanding a person's fear doesn't excuse what they did with it. It only explains it. Ashley had watched her own father's business fail twice. She had grown up on the version of financial anxiety that never quite becomes poverty but never stops circling it either, always one bad year from the bottom falling out. When she married into the Callaway name, into a $16 million business and a husband who was, technically, the only son, I believe she assumed the ground under her feet had finally gone solid. Derek's mounting debt terrified her in a way I don't think Derek himself ever fully grasped. She was the one, I would later learn, who first raised the idea that Derek needed to secure his inheritance before I could complicate it. I noticed the distance growing between Derek and me in the 2 years before Hal's stroke, though I told myself at the time it was nothing more than a grown man building his own life and needing less from his father's house. He stopped calling on Sundays, the way he had for over a decade. He started declining our invitations to Christmas dinner in favor of spending the holiday with Ashley's family in Winston-Salem instead, a choice I never once resented out loud, because a wife's family deserves its own claim on a holiday too. But I remember one visit, 18 months before the stroke, when Derek walked through our house looking at the renovated kitchen, the new roofline on the east wing, the expanded parking lot behind the boutique hotel we drove past on our way from the airport, and he said, quietly, almost to himself, "Dad's really built something, hasn't he?" There was an odd flatness to the way he said it, not pride exactly, something closer to inventory. I noted it the way I note most things, and then I let it go, because noting something and understanding it are two very different skills, and I did not yet have the second one pointed in the right direction. 2 Thanksgivings before Hal's stroke, Ashley said something at our table I noted at the time and understood far too late. She looked around our dining room, at the house Hal and I had built our life in, and she said, "It's strange, isn't it, how none of this technically has Derek's name on it?" Hal laughed it off. Family jokes about money at holiday tables, harmless, the kind of comment you forget by dessert. I didn't forget it. I have spent 32 years learning to notice the sentence that isn't really a joke. I just didn't yet know what to do with what I'd noticed. Hal had his stroke on a Sunday morning in March, in our kitchen, while I was at the grocery store. I came home to find him on the floor by the coffee maker, conscious but unable to lift his right arm, his words coming out slurred and slow. I called 911 with a steadiness that surprised even me, 32 years of professional composure taking over exactly when I needed it most, and I rode with him to Mission Hospital and sat in that waiting room until a doctor came out and told me he'd survive it, but that recovery, especially cognitive recovery, was uncertain. Hal spent the first 11 days in the ICU. He came home to us partially, in stages, the way stroke patients do. His speech improved faster than his memory. Some days he was entirely himself, sharp enough to correct me on a property tax figure from a decade earlier. Other days he asked me the same question 4 times in an hour and grew agitated when I answered it the same way each time. His neurologist, Dr. Susan Yates, told us this was consistent with what she called fluctuating post-stroke cognitive impairment, a condition where capacity isn't a single line a person crosses once, but a door that opens and closes, sometimes within the same afternoon. I wrote her exact words down in a notebook I started keeping the week Hal came home, not because I suspected anything yet, but because 32 years of trust work had taught me to document everything involving a diminished person's finances, out of habit, out of instinct, the way some people lock a door without thinking about it. Derek started coming to Asheville more often after the stroke. Every weekend at first, then some weekdays too, taking personal days from the mortgage firm, which struck me as touching before it struck me as strategic. He'd sit with Hal for hours, watching golf, talking about the office parks, asking Hal question after question about the business, how the storage complexes were financed, who held which deeds, what percentage of the hotel Hal actually owned outright versus what was leveraged. I thought it was a son reconnecting with a father he'd nearly lost. I thought it was sweet, a grown man finally asking the questions he'd been too proud or too busy to ask for 20 years. I was wrong about what those questions were for. 6 weeks after the stroke, on a Thursday when I had a scheduled half-day at Green Ridge and wasn't expected home until 3, Derek arrived at our house with a man I didn't recognize. Ashley came too. The man carried a leather portfolio and introduced himself, when I finally met him weeks later, as Nathaniel Cross, an estate attorney with an office above a nail salon in a strip mall outside Charlotte, a man whose bar license, I would later learn, had already carried 2 prior complaints for questionable dealings with elderly clients, both dismissed for lack of sufficient evidence, both worth remembering. That Thursday, according to what I eventually pieced together, Hal was having what Dr. Yates would call a fluctuating episode, a bad afternoon, the kind where he called our housekeeper by his first wife's name and grew confused about what year it was. Derek and Nathaniel Cross sat with him at our kitchen table for 40 minutes. At the end of those 40 minutes, Hal signed a codicil to his trust, witnessed by Ashley and notarized by a woman named Renee Boyd, a friend of Nathaniel Cross's who ran a small notary service out of a UPS store and who, it would later come out, had not actually watched Hal sign the document in person, but had notarized it 2 days later based on Cross's representation that the signing had occurred properly. The codicil named Derek as sole successor trustee of the Callaway Family Trust and primary beneficiary of the entire estate, an estate that, when the properties, the businesses, and the investment accounts were finally appraised, came to just over $16 million. It removed me entirely. Not reduced my share. Removed it. The document stated that Hal wished to simplify the estate by consolidating control in his sole surviving child, in recognition of Derek's steady support during a difficult family transition. I read that sentence more times than I can count in the weeks that followed, and every time, the phrase difficult family transition landed a little differently, because I understood, eventually, that the transition it referred to wasn't Hal's stroke. It was preparing the family for my exit. Hal died 61 days after the stroke, of a second, larger stroke in the night, in a hospital bed, with me holding his hand and Derek 2 hours away in Charlotte, not answering his phone until morning. I want to say clearly that I do not believe Derek caused his father's death, and nothing in this story suggests he did. What Derek did was worse in a slower, quieter way. He watched his father's mind flicker in and out of clarity for 6 weeks, and in one of the flickers, he walked a lawyer into our kitchen. 4 days after the funeral, Derek called a family meeting at our house. He brought Ashley. He brought a copy of the codicil in a manila folder that Nathaniel Cross had prepared for him. I sat at the same kitchen table where, I would later learn, that document had been signed, and Derek slid the folder across to me with a steadiness I found chilling in a man who was supposedly grieving his father alongside me. "Vivian," he said, "I think it's best we handle this cleanly. Dad wanted things simplified. This is his codicil. I'm the sole trustee and beneficiary now." He paused, and then he said the sentence that gives this story its title, the sentence I have not been able to stop hearing since. "You're not getting anything, Vivian." I'm sorry, but that's what he decided. I looked at the document. I recognized Nathaniel Cross's letterhead immediately, a firm I had never once heard Hal mention in 28 years of managing our finances together. I looked at the notary stamp, Renee Boyd, a name that meant nothing to me. I looked at the date, 6 weeks after the stroke, in the exact window when Hal's neurologist had documented, in writing, that his capacity was fluctuating and unreliable. I did not raise my voice. 32 years behind a trust desk teaches you that the first reaction to a suspicious document is never the loudest one. It's the quietest one, the one where you start reading instead of reacting. Derek, I said, have you actually read the trust documents, or did somebody read them to you? He didn't answer. Ashley answered for him. It's legally binding, Vivian. Nathaniel says it's airtight. I looked at her. I looked at Derek. And I said the only thing I was certain of in that moment. I'll need some time to review this properly. Then I stood up, thanked them for coming, and walked them to the door the way I would walk any client out of an appointment that required further documentation before I could act on it. Calm. Procedural. Giving away nothing. I want you to understand what I did next, because it wasn't grief, not yet. Grief was waiting for me, patient, in the corners of a house that still smelled like Hal's aftershave. What I did first was walk to the study, sit down at Hal's desk, and start a file. I have built 100 files like it professionally. I had never built one for my own life. Stay with me. If you've ever had someone hand you a piece of paper and tell you it erases 30 years of your life, you know exactly what that kitchen table felt like. This is where it turns. Green Ridge Trust taught me one rule above every other rule. When a document surfaces that changes an estate at the last possible moment, in favor of the person who happened to be closest to the decedent when his capacity was weakest, you do not argue about fairness. You investigate the document's construction. Paper tells the truth even when people don't. I started with the timeline, because timelines are the first thing that break in a rushed scheme. I pulled Dr. Yates's medical records, which I was legally entitled to as Hal's surviving spouse, and laid them beside the codicil's execution date. The codicil was signed on a Thursday. Dr. Yates's chart notes from the Tuesday before that same week documented, in her own clinical language, patient exhibiting significant confusion regarding time orientation and recent memory, recommend caution regarding any decisions requiring sustained cognitive engagement. 2 days before Derek walked Nathaniel Cross into my kitchen, Hal's own doctor had written a warning that read almost like a prophecy of exactly what was about to happen to him. I called Dr. Yates directly. I had known her for the full 61 days of Hal's recovery, sat across from her in a dozen consultations, and she remembered me warmly enough to take my call without hesitation. I told her what had happened. I asked her, carefully, professionally, whether she would be willing to review her own notes and offer a clinical opinion on Hal's capacity during the 6-week window after his stroke. Vivian, she said, I document capacity concerns for exactly this reason. Send me the date on that codicil. I'll tell you what I can say about it. I sent her the date. Her answer came back within 2 days, in writing, on Mission Hospital letterhead. In her clinical opinion, based on documented fluctuating post-stroke cognitive impairment, Harold Calloway's capacity to understand and execute a legally binding financial document on the date in question was, in her words, significantly compromised and unreliable without corroborating evidence of a lucid interval at the specific time of signing. That was the first tab in my file. Next, I went after the notary. 32 years in trust work means I know exactly what a properly executed notarization requires in North Carolina. The notary must personally witness the signature. She must verify the signer's identity. She must record the transaction in a notary journal with a date, a description of the document, and the signer's signature or thumbprint. I called the North Carolina Secretary of State's office and requested the public record of Renee Boyd's notary journal entries for the relevant month. It took 12 days and one formal records request through my attorney, but it came back, and when it did, it told me everything. Renee Boyd's journal listed the codicil's notarization as occurring on a Saturday, 2 full days after the date printed on the document itself. Her journal entry recorded the transaction location as her UPS store office in Charlotte, not our kitchen table in Asheville, 90 minutes away. Hal Calloway, 61 days removed from a stroke that had already taken most of his mobility on his right side, had not traveled to Charlotte on a Saturday to sign anything. He hadn't left our house except for medical appointments in the final 6 weeks of his life. The notarization was fraudulent on its face, a stamp applied to a document the notary never actually witnessed being signed, in direct violation of state law. Before I called Margaret, I did one more thing, quietly, on a Saturday morning while the house was empty. I drove out to the Buncombe County Register of Deeds and pulled every filing associated with Calloway Properties Group from the previous 18 months, the ordinary due diligence of a trust officer who no longer had an office to do it from but hadn't forgotten how. I wanted to know whether Derek had attempted to transfer or encumber any of the properties directly, whether the scheme extended beyond the codicil into something already touching the deeds themselves. It hadn't, not yet. Every deed still listed Hal, and after his death, the estate, as sole owner, untouched. That single trip told me something important I carried with me into every conversation that followed. Derek and Ashley had been fast, but they hadn't been thorough. They had built one document and assumed one document would be enough, the same mistake I have watched dozens of families make across 3 decades of trust work. A scheme built in a hurry always leaves gaps, and I have spent my whole career being the person paid to find them. I hired Margaret Feld, an estate litigation attorney in Asheville who Green Ridge had referred families to for over a decade and who I had worked alongside professionally on 3 separate contested trusts during my career. I trusted her before I ever needed her personally, which is its own kind of luck. I laid out what I had. The medical records. The notary journal discrepancy. The timeline. Margaret read through it at her conference table without speaking for almost half an hour, the way Dr. Yates had read my case notes, the way I had read 4,000 estate files across 3 decades, methodically, missing nothing. Vivian, she finally said, in 22 years of estate litigation, I've seen maybe a dozen files documented this cleanly, and none of them were built by the person the fraud was committed against. This is textbook undue influence, layered with a fraudulent notarization and a serious capacity question. We can absolutely challenge this codicil in probate court. I'm not ready to file yet, I told her. I want the complete picture first. Margaret understood that instinct better than most attorneys would have, because she'd watched me build files for other families for years and knew I never moved on incomplete information. Then let's build it completely, she said. Over the following 4 months, I built. I want to walk you through exactly how, because the how is the entire reason this story ends the way it does. I subpoenaed, through Margaret, the phone records associated with Nathaniel Cross's office line and Derek's personal cell. They showed 11 calls between Derek and Cross's office in the 8 days before the codicil was signed, and only 2 calls in the entire 2 years prior. A relationship that had barely existed suddenly intensified into daily contact in the exact week that mattered. I pulled bank records for our joint accounts, records I had every legal right to as Hal's spouse and as a longtime cosigner. I found a $5,000 check written from Hal's personal account, the one Derek had access to as an authorized signer for handling small bills during his father's recovery, made out directly to Nathaniel Cross's law office, dated the same week as the 11 phone calls. Derek had paid the attorney who drafted the document that erased me, using his incapacitated father's own money to fund it. I found Ashley's texts. This part 1 did not obtain through subpoena. Derek's laptop still sat in our guest room from a weekend visit, and while I want to be honest that I am not proud of reading messages that weren't addressed to me, I also want to be honest that 32 years of professional instinct told me exactly where to look, and I looked. Ashley had texted her sister, a woman named Courtney who lived in Raleigh, 4 months before Hal's stroke even happened. Derek's dad is worth like $16 million and none of it is technically Derek's yet. If something happens to him before they update the paperwork, Vivian gets everything. We need to talk to Derek about protecting his interest. That message was dated months before the stroke. It told me something I had not wanted to believe. This wasn't a plan born out of grief or opportunism in a vulnerable moment. This was a plan Ashley had been quietly building toward before Hal ever collapsed in our kitchen, and the stroke simply handed her the opening she'd already been waiting for. I found more messages, later ones, after the stroke, between Ashley and Courtney. He's having a bad day today, confused about what year it is. Derek thinks this might be the window to get Nathaniel out here. Sent the Tuesday before the signing, the exact day Dr. Yates documented Hal's confusion in her chart notes. Ashley had been tracking Hal's cognitive episodes the way a person tracks weather before a flight, waiting for the specific conditions that would let the scheme land. I photographed every message. I did not delete anything, did not alter anything, did not touch the laptop again after that single session. Margaret later confirmed that the photographs, while obtained in a way she cautioned might face admissibility challenges depending on how they were used, corroborated everything the phone records and bank records already proved independently. The digital trail wasn't the foundation of my case. It was confirmation of a foundation I'd already built from records nobody could challenge: hospital charts, notary journals, bank statements, phone logs. I want to tell you about one more witness, because she mattered more than any document in the end. Renata Alvarez had been Hal's home health aide during the final 3 weeks of his life, a hospice-trained nurse who came 6 days a week to help with his medication, his physical therapy, his meals. She had been in our house nearly every day during the exact window the codicil was signed, though not, as it happened, on the specific Thursday itself. But Renata had been present the day before and the day after, and she had her own professional notes, kept independently for the hospice agency she worked through, documenting Hal's condition daily. I called Renata 6 weeks into my investigation, after I'd already built most of the file, because I wanted to know if her records corroborated Dr. Yates's. She agreed to meet me at a coffee shop near her agency, off the clock, on her own time. She brought her own copies of her daily notes, which she was entitled to share as they documented her own professional observations. The Wednesday before the signing, her notes read: patient disoriented upon waking, did not recognize date, asked twice about deceased first wife as though she were still living. The Friday after, her notes documented Hal asking her who the man in the leather portfolio had been, with no memory of signing anything at all. I liked your husband very much, Mrs. Calloway, Renata told me. He talked about you every single day I worked with him. If what you're telling me is true, about that codicil, I'll say what I observed under oath. That's not opinion. That's just what I wrote down as it happened. Somewhere in the middle of those 4 months, I finally told someone the whole truth outside of Margaret's office. My closest friend, Doreen Whitfield, had worked beside me at Green Ridge for 26 years before retiring 3 years ahead of me, a fellow trust officer who understood exactly what kind of documents I was pulling and exactly why my hands shook a little every time a new record arrived by courier. We met for coffee at a diner off Marymount Avenue, the same corner booth we'd used for decades of work lunches, and I laid it all out for her the way I'd laid it out for Margaret, methodically, folder open on the table between the sugar packets and the coffee cups. Vivian, she said, when I finished, how long have you been carrying this by yourself? 4 months. And you didn't call me. I needed the case finished before I told anyone who wasn't building it with me. You taught me that yourself, Doreen. Don't discuss an open file. She reached across the table and put her hand over mine, the way she used to when we'd close out a difficult estate together back at the office, both of us too tired to celebrate properly but needing some small gesture to mark that the work was done right. You're not at Green Ridge anymore, she said. You don't have to run this like a case number. But if you need someone in that courtroom who isn't your lawyer and isn't blood, I'll be there every single day you need me. She kept that promise. Doreen sat in the gallery behind our table for both days of the hearing, arriving before I did each morning with 2 coffees, one for her and one for me, black, the way I've taken it since I was 22 years old and pouring it for other people's clients. Having her there mattered more than I let on to anyone, even to Margaret. There is a particular strength in being flanked by someone who has watched you do careful, unglamorous work for decades and has never once doubted you would do it again when it counted most. That was the moment my case stopped being a file and became something I could actually walk into a courtroom carrying. 5 months after Hal's death, Margaret Feld filed a formal challenge to the codicil in Buncombe County Probate Court, on 3 separate grounds: lack of testamentary capacity, undue influence, and fraudulent execution due to the improperly performed notarization. The filing named Derek Calloway and, separately, referred Nathaniel Cross's conduct to the North Carolina State Bar for investigation, and referred Renee Boyd's notary practices to the Secretary of State's office for review. Derek retained his own attorney once the filing landed, a man far less experienced than Margaret in estate litigation, which told me something about how competent Derek had genuinely been that no one would ever look closely enough to catch what he'd done. I don't think Derek believed I would fight. I think he believed a 63-year-old widow would grieve quietly and accept whatever piece of paper was placed in front of her, the way people sometimes assume grief and capability can't exist in the same person at the same time. The hearing was scheduled for a Tuesday morning in October, 7 months after Hal's death, in the Buncombe County Courthouse, before Judge Elena Marsh, a probate judge with 18 years on the bench and a reputation, Margaret told me, for having very little patience with documents that didn't hold up to scrutiny. The week before the hearing, I sat at Hal's desk in the study, the same desk where I'd started this whole file, and I organized everything one final time the way I organized every complicated trust one ever managed professionally. Tab 1, Dr. Yates's medical records and written clinical opinion on capacity. Tab 2, Renee Boyd's notary journal record, showing the impossible 2-day discrepancy between the signing date and the notarization date. Tab 3, the phone records showing 11 calls between Derek and Nathaniel Cross's office in 8 days. Tab 4, the bank record showing the $5,000 check from Hal's account to Cross's firm. Tab 5, Ashley's text messages to her sister, dated months before the stroke and again the day before the signing. Tab 6, Renata Alvarez's independent hospice notes documenting Hal's confusion the day before and his complete lack of memory of the signing the day after. Tab 7, a full appraisal of the $16 million estate, prepared by an independent appraiser Margaret had retained, showing precisely what was at stake. I had the folder bound at a copy shop the way Margaret's office always bound exhibits for court, tabbed, numbered, a table of contents on the first page. I held it in both hands the night before the hearing the way I used to hold finished trust documents before delivering them to a family, checking every page one final time, not because I doubted its accuracy, but because I wanted to walk into that courtroom knowing every single word inside it cold. Stay with me. Tomorrow morning, I was going to sit across a courtroom from my own stepson and let a judge decide whether 32 years of professional precision could undo what 6 weeks of exploited confusion had tried to take. If you've ever had to prove, with paper, what your own family refused to see with their eyes, you already know how this feels. Drop a comment if you've ever had to build a case just to be believed. The Buncombe County Courthouse smells like every government building I've ever walked into professionally, floor wax and old paper and the particular hush of a room where consequences get decided. I wore a navy suit, the same kind I wore to close out complicated trust accounts for 32 years, because some part of me understood that I needed to walk into that room as Vivian Calloway, trust officer, not Vivian Calloway, grieving widow. Grief would not win this. Precision would. Judge Elena Marsh sat behind a raised bench, reading glasses pushed low on her nose, a woman who had clearly read every filing in advance and had no patience for theater. Margaret sat beside me at our table, my bound exhibit folder squared in front of her. Derek sat at the opposing table with his attorney, a younger man named Chad Ferris who kept glancing at his notes like he wasn't entirely sure what was coming. Ashley sat in the gallery behind Derek, in a cream-colored dress, her hands folded in her lap the way a person sits when they're trying very hard to look like they have nothing to hide. Nathaniel Cross was not present. He had, Margaret told me quietly before the hearing began, retained his own counsel after receiving formal notice of the State Bar referral, and had declined to appear voluntarily. Judge Marsh opened by summarizing the petition. A challenge to a codicil executed 6 weeks after the decedent's stroke, on grounds of capacity, undue influence, and fraudulent execution. Ms. Feld, she said, proceed with your case. Margaret called Dr. Susan Yates first. Dr. Yates walked through Hal's medical history with the unhurried clarity of a physician who had testified in court before, describing the stroke, the recovery trajectory, and the specific pattern of fluctuating cognitive impairment she had documented in real time, in her own contemporaneous chart notes, not reconstructed after the fact for litigation, but written down on the actual days those symptoms occurred. When Margaret asked her opinion on Hal's capacity on the specific date the codicil claimed to have been signed, Dr. Yates answered without hesitation. Based on my documented clinical notes from 2 days prior showing significant disorientation, and my professional experience with fluctuating post-stroke cognition, I cannot state with medical confidence that Mr. Calloway possessed reliable testamentary capacity on that date without independent corroboration of a lucid interval, which I have seen no evidence of in this case. Chad Ferris's cross-examination tried to suggest that Dr. Yates couldn't know Hal's exact state on a day she hadn't personally examined him. Dr. Yates answered calmly that this was precisely why proper legal execution of a document involving a recovering stroke patient required independent verification of capacity at the moment of signing, verification that, notably, nobody in that courtroom could produce, because no one had ever obtained it. Margaret called Renee Boyd's notary journal into evidence next, entering it as tab 2, walking Judge Marsh through the 2-day discrepancy between the signing date printed on the codicil and the notarization date recorded in Boyd's own journal, along with the location discrepancy, a UPS store in Charlotte versus a kitchen table in Asheville, 90 minutes apart. Your Honor, Margaret said, under North Carolina law, a notary is required to personally witness the execution of a document at the time and place of signing. This journal entry, kept by the notary herself in the ordinary course of her business, establishes on its face that this notarization did not comply with that requirement. The document is fraudulently executed regardless of any other issue in this case. Judge Marsh looked up from the journal copy for the first time since the hearing began. Ms. Feld, is Ms. Boyd available to testify? She's on our witness list, Your Honor, if the court wishes to hear from her directly. The court did. Renee Boyd, when called, admitted under oath, visibly uncomfortable, that she had not been physically present when Hal Calloway signed the codicil, that Nathaniel Cross had brought her the already signed document 2 days later and asked her to notarize it as a favor, and that she had done so believing, in her words, that it was just a formality since Nathaniel said the signing was legitimate. Judge Marsh made a note. I watched her pen move and understood, for the first time since the hearing started, that we were winning. Margaret entered the phone records as tab 3 and the bank record as tab 4, walking the court through the 11 calls in 8 days between Derek and Nathaniel Cross's office, and the $5,000 check drawn from Hal's personal account, signed by Derek under his limited authority as a bill pay signer during his father's recovery, made payable directly to the attorney who drafted the very document that disinherited me. Your Honor, Margaret said, Mr. Calloway used his incapacitated father's own funds to retain the attorney who then drafted a document stripping the father's wife of her entire interest in a $16 million estate, in the exact window his father's own physician had documented as cognitively unreliable. When Margaret introduced Ashley's text messages as tab 5, Chad Ferris objected on grounds of how the messages had been obtained. Judge Marsh allowed Margaret to lay foundation, and Margaret called Ashley's sister, Courtney, who had been served a subpoena weeks earlier and who, under oath, confirmed she had received both messages from Ashley, the one sent months before Hal's stroke discussing protecting Derek's interest before the $16 million was technically his, and the second sent the day before the signing, tracking Hal's confusion as a window of opportunity. Courtney's own testimony authenticated the messages independent of how I'd first come to see them on Derek's laptop, which resolved Chad Ferris's objection entirely. I watched Ashley in the gallery as her sister spoke. She did not cry. She stared at a point on the wall above the judge's bench and did not move. Before Renata, Margaret called a forensic document examiner named Curtis Wren, an expert witness she'd used in prior estate contests, who had analyzed the codicil signature against exemplars pulled from 20 years of Hal's business documents on file at Green Ridge and at the County Register of Deeds. Curtis testified that while the signature itself was consistent with Hal's hand, the pen pressure and letter formation showed what he described as significant stroke irregularity consistent with a signer experiencing fine motor impairment, a finding that aligned precisely with Hal's known right-side weakness following his stroke, and that, in his professional opinion, was inconsistent with the fluent, confident signature style found in every one of Hal's business documents from the 20 years prior. It wasn't proof of forgery. Nobody claimed the signature wasn't Hal's own hand. But it was one more thread in a rope Margaret was weaving carefully, tab by tab, each strand thin enough to argue with alone and impossible to untangle once they were braided together. Finally, Margaret called Renata Alvarez, the hospice aide, as tab 6. Renata testified simply, in the plain, unembellished language of a professional reading from her own contemporaneous notes, describing Hal's disorientation the Wednesday before the signing and his complete lack of memory of having signed anything the Friday after. He asked me who the man in the suit had been, she said. He didn't remember signing his name to anything. I wrote that down this same day because it concerned me as his caregiver. Judge Marsh asked few questions during the presentation of evidence. She asked several once Margaret rested our case. She asked Chad Ferris directly whether the defense had any independent evidence, medical or otherwise, corroborating that Harold Calloway possessed reliable capacity on the specific date and at the specific moment the codicil was executed. Chad Ferris did not have an answer that satisfied her, because there was no such evidence to offer. There never had been. Derek and Nathaniel Cross had built a document on the assumption that no one would ever look closely enough to ask that exact question, and I had spent 5 months making sure someone did. Margaret called Ashley to the stand next, before Derek, and I watched my daughter-in-law walk to the witness box in her cream-colored dress with the same careful posture she'd carried into our house the day she and Derek brought Nathaniel Cross to our kitchen table. Under Margaret's questioning, Ashley confirmed she had witnessed the codicil signing. When Margaret asked her to describe Hal's demeanor that day, Ashley said he had seemed totally normal, sharp as ever. When Margaret then asked her to explain the text message to her sister, sent 4 months before Hal's stroke, referencing the need to protect Derek's interest in an estate that wasn't yet his. Ashley's composure cracked for the first time in the proceeding. "That message doesn't mean what it sounds like," she said. "I was just thinking ahead." "Any wife would think ahead. Ms. Calloway," Margaret said, "were you thinking ahead the day before the signing, when you texted your sister that your father-in-law was, in your words, having a bad day and that this might be the window to get Nathaniel out here?" Ashley didn't answer right away. Judge Marsh asked her to respond to the question. "I don't remember the exact wording," Ashley finally said. "Your sister does," Margaret said. "She testified to it under oath 20 minutes ago." Ashley had no answer for that either. She was excused from the stand a few minutes later, and she did not look at me on her way back to the gallery. I noticed, watching her go, that her hands were shaking, the first honest thing I'd seen from her all day. When Derek took the stand under questioning from his own attorney, he testified that his father had seemed lucid to him that day, that Hal had spoken clearly about wanting to simplify the estate. Under cross-examination from Margaret, he could not explain the 2-day gap in the notarization. He could not explain the $5,000 check. He could not explain the 11 phone calls in 8 days after 2 years of near silence with Nathaniel Cross's office. He grew visibly frustrated, his voice rising for the first time in the proceeding. Margaret asked him, calmly, why, if the codicil truly reflected his father's clear and settled wishes, he had never once mentioned its existence to me in the 7 weeks between the signing and Hal's death, 7 weeks in which Derek visited nearly every weekend and sat across from me at that same kitchen table more times than I could count. Derek didn't have an answer that held together. He said his father had wanted to tell me himself, in his own time, when he was stronger. He said he hadn't wanted to upset me while Hal was still recovering. Margaret pointed out, gently, that Hal never recovered enough to tell me anything, and that the silence Derek was describing as consideration looked, on paper, exactly like concealment. That was when he said the sentence I will remember for the rest of my life. "She's not even his real family. I'm his son. It should have always been mine." Judge Marsh let that sentence sit in the room for a long moment before she spoke again. "Mr. Calloway," she said, "this court does not determine inheritance based on who is owed something by blood. It determines inheritance based on the validly and lawfully expressed intent of the decedent. And I have seen no lawful evidence that your father's intent was ever validly expressed in this document." Judge Marsh took a 15-minute recess before delivering her ruling. I sat beside Margaret in the empty hallway outside the courtroom, my folder closed on my lap, and I did not speak, because there was nothing left to say that 32 years of my professional life hadn't already said through the documents themselves. When we returned, Judge Marsh ruled from the bench. She found, based on the totality of the evidence, that the codicil executed 6 weeks after Harold Calloway's stroke was invalid on all 3 grounds raised in the petition: lack of demonstrated testamentary capacity, undue influence exercised by Derek Calloway and Ashley Calloway in coordination with attorney Nathaniel Cross, and fraudulent notarization by Renee Boyd in violation of North Carolina notary law. She ordered the codicil set aside in its entirety, restoring the original trust document Hal and I had executed together 9 years earlier, the one that named me primary beneficiary and successor trustee of the Calloway Family Trust, with a smaller, specific bequest to Derek that Hal himself had chosen freely, years before any stroke, years before any leather portfolio walked into our kitchen. She referred the matter of the fraudulent notarization to the Secretary of State's office for formal license review, and she noted for the record that the court's findings regarding Nathaniel Cross's conduct would be forwarded to the state bar's pending investigation. She did not refer Derek or Ashley for criminal prosecution that day, noting that such a decision rested with the district attorney's office based on the court record now established, but she stated clearly, for the transcript, that the pattern of conduct documented in the evidence was, in her words, deeply troubling and warrants further review. I did not smile in that courtroom. I did not cry either. I sat with my hands folded on the closed exhibit folder, and I felt, more than anything else, the specific exhaustion of a job finally, correctly finished. Derek did not look at me on his way out of the courtroom. Ashley did, once, from the doorway, a look I have turned over in my mind many times since and still cannot fully name. Not quite hatred. Something closer to disbelief, the particular disbelief of a person who has never once in her life been caught doing something she assumed was invisible. In the weeks after the ruling, the district attorney's office opened a review of the financial records Margaret's filing had surfaced, focused primarily on the $5,000 check drawn from Hal's account under Derek's limited signing authority, an authority that, under North Carolina law, did not extend to retaining legal counsel for purposes adverse to the account holder's own estate. That review is, as of the time I'm telling you this, still ongoing, and I have deliberately chosen not to push for a specific outcome, because I built this case to restore what was taken, not to punish beyond what the evidence itself demands. Margaret disagrees with me gently on this point. She thinks Derek and Ashley got off lighter than the facts warranted. I think 32 years of watching families destroy each other over money taught me that some consequences are better left to unfold on their own timeline than forced by a widow who's already gotten back what mattered most. Nathaniel Cross's law license was suspended by the North Carolina State Bar 4 months after the hearing, pending a full investigation that ultimately substantiated the findings from Judge Marsh's courtroom, along with troubling patterns in 2 other estate matters investigators found once they started looking closely at his practice. Renee Boyd surrendered her notary commission voluntarily rather than face a formal revocation hearing. I understand she no longer works at the UPS store either, though I did not go looking for that information. Some doors, once you've documented what walked through them, you're allowed to simply close. Derek and Ashley's marriage did not survive the year following the hearing. I heard this the way you hear most things in a town the size of Asheville, secondhand, through people who still know both families. I felt no satisfaction in it, which surprised me. I had spent 5 months building a case against my stepson with a precision that sometimes frightened even me, and when it was finally over, what I felt toward him wasn't triumph. It was grief, layered over grief, because somewhere underneath everything Derek did, I still saw the 12-year-old boy who used to sit in the back seat of my car after soccer practice, careful never to let me see him need anything. 6 months after the ruling, Derek called me. I almost didn't answer. I sat with the phone in my hand for 4 full rings before I picked it up. "Vivian," he said, and his voice sounded smaller than I'd heard it in years, "I don't expect you to forgive me. I don't think I'd forgive me either. I just needed you to know that I know what I did." Ashley pushed, and I let her, because it was easier than saying no to the person telling me I finally deserved something. But I signed on to it. I made the calls. I wrote the check. That's on me. I sat with that for a long moment before I answered. "Your father spent 5 months slipping in and out of himself, Derek, and in one of the moments he wasn't fully there, you and your wife decided that was the moment to act instead of the moment to wait. I understand why you wanted more than he'd already given you. What I can't understand is why you thought taking it from a confused, dying man was the same thing as earning it." He didn't have an answer to that. I didn't expect one. Some conversations aren't meant to end in resolution. They're meant to end in honesty, and that was the most honest exchange Derek and I had shared in 28 years of knowing each other. I go to Hal's grave most Sundays now, at Riverside Cemetery, where the old sections have oak trees old enough to remember a version of Asheville neither of us ever saw. I bring flowers from the garden he planted the year we bought the house, and I sit on the small stone bench I had installed the spring after his death, and I tell him about the properties, about the hotel's best quarter yet, about Doreen's grandchildren, about all the small, ordinary things a marriage is actually made of once the extraordinary parts, the courtroom, the fraud, the betrayal, have finally quieted down. I told him, the Sunday after the ruling, that I'd kept my promise. He always trusted me to keep the business running if anything happened to him. He just never imagined I'd have to fight his own son to be allowed to keep that promise at all. I still hold the specific bequest Hal originally intended for Derek in trust, exactly as the restored document lays it out, because a court order doesn't erase a father's original wishes, and I was never trying to erase Hal's love for his son. I was only ever trying to stop that love from being twisted into a weapon aimed at me. The trust remains intact for Derek's future, administered independently, released to him under the same terms Hal set 9 years before any of this happened, terms neither Derek nor I have the power to change. Some inheritances need protecting even from the people who committed fraud to enlarge them. I held a small dinner at the house the December after the ruling, the first Christmas I hosted alone in 28 years. I invited Doreen and Frank. I invited Margaret and her husband. I invited Renata, who I'd come to think of as something closer to family than the family who'd tried to erase me. I did not invite Derek or Ashley, and I want to be honest that this was a decision I made carefully, not out of spite, but out of the plain fact that some tables need time to become safe again before certain people are welcome back at them. I set out Hal's mother's china, the good plates we only used twice a year, and I made his favorite roast, the same recipe I'd made him every Christmas for nearly 3 decades. I raised a glass before dinner, not to the business, not to the ruling, but to Hal himself, to 32 years of a marriage that taught me exactly the skills I would need to protect what he left behind. Doreen cried a little. So did I. It was, strangely, one of the better Christmases I've had in years, because it was honest in a way holidays in that house hadn't always managed to be. Renata Alvarez still sends me a card every year around the anniversary of Hal's death, a small kindness I did not expect from a woman I paid to care for my husband for only 3 weeks of his life. Last spring, I hired her directly, privately, to help care for Doreen's husband Frank after his own health began to decline, because I trust her judgment more than I trust almost anyone else's in matters of a person's final, most vulnerable season. She told me once, over coffee, that she'd testified in 2 other capacity cases since ours, always for families who found her the same way I did, by asking the question most people are too polite or too frightened to ask out loud. Was my loved one really all there the day they signed that? Margaret and I still meet for lunch every few months, no longer as attorney and client, but as 2 women who went through something together and came out the other side of it still standing. She told me, the last time we spoke, that our case had become something of a teaching example at her firm, cited to younger associates as a model of what a properly documented capacity and undue influence challenge looks like when the petitioner does the investigative groundwork herself before ever walking into an attorney's office. I told her I hadn't done anything younger associates couldn't learn to do themselves. I'd simply spent 32 years learning never to trust a document just because someone handed it to me with confidence. Last month, I sat down with a young trust officer at Green Ridge, a woman named Priya who reminded me a great deal of myself at 26, sharp and careful and slightly too eager to prove she belonged in rooms full of people who assumed she didn't. I told her about this case, not the names, not the specific numbers, but the shape of it, because I think the next generation of people in my profession needs to understand something I only fully understood myself at 63. The most dangerous moment in any family's finances isn't when someone is healthy and clear-eyed and making decisions with full understanding. It's the narrow window when someone is vulnerable, confused, and surrounded by people who have decided that window is an opportunity instead of a responsibility to protect. I think often about the difference between the two men Derek could have chosen to be in those 7 weeks. There was a version of that spring where my stepson sat with his confused, recovering father and simply kept him company, read him the sports section, reminded him gently what day of the week it was, and let the rest of the estate settle itself in its own time, the way hell had already arranged for it to settle 9 years earlier. That version of Derek would have inherited exactly what his father intended for him, freely given, no fraud required, no courtroom necessary. Instead, he chose the version where he walked a stranger with a leather portfolio through my front door during the one window his father's mind wasn't reliable enough to say no. I don't know that Derek understood, in the moment, that he was choosing between those two versions of himself. I think Ashley's fear moved faster than his judgment did, and I think, in the end, that is not an excuse either of them gets to keep. If there's one thing I would ask you to take from my story, it's this. Document everything, especially the moments when the people you love are least able to protect themselves. Keep records nobody asked you to keep. Ask questions even when asking them feels rude, or paranoid, or like you're accusing someone before they've done anything. I built the case that saved my life's work using nothing but paper other people assumed I'd never think to look at: medical charts, a notary journal, a $5,000 check, a handful of text messages sent months before anyone thought a stroke was coming. None of it was hidden particularly well. It was simply hidden from people who didn't know how to look. I know how to look. 32 years taught me that. And on the day my own family tried to write me out of a life I helped build, that was the one thing they forgot to account for. My name is Vivian Calloway. I'm 63 years old. My stepson stood in my foyer and told me I would get nothing from his father's estate. He was wrong, and the paper trail is the reason he was wrong. If you've ever been told you don't count in your own family's story, tell us about it in the comments below. If this reminded you of someone strong enough to prove them wrong, share it with her today. Subscribe to Gia Mom Stories for more, and remember, the quietest person at the table is usually the one who's been paying attention the longest.